Hello students, welcome to the Recitals in-depth session. In this session, we are going to discuss the topics which are featured in the section of Polity and Governance for the month of April 2024. The topics that we are going to cover are broadly falling under the themes of fundamental rights, federalism, judiciary, elections and sports governance. Now, as we know that India is a federal country, and since independence there has been a constant tug of war between the central and the state government with respect to the matters which these units of government can actually legislate on. And in this topic, the matter is exactly the same. So in this topic, we are going to discuss the power of the state governments to levy excise duties on the industrial alcohol. Now, coming to the context, what is the important context and why we are trying to learn or understand this particular topic. So recently, a 9-judge Supreme Court bench is going to deliberate and discuss whether the state governments are legislatively competent enough to levy or regulate the industrial alcohol. Now, what do we understand by the term regulating? So here the term regulate means to regulate the prices, consumption, distribution, possession and commercial aspects with vis-a-vis the industrial alcohol. And why this particular topic is very important for us. So the first point is that constituting a 9-judge Supreme Court bench is not a small feat. And we have seen in our political history that whenever such kind of larger benches are constituted, it holds very eminent significance for our entire political and administrative setup. Second is, since it is a constitution bench, it is going to reframe or recalibrate the relationship between the center and the state governments and under what matters each units of government are able to legislate. And thirdly, since we know that the alcohol forms a very important aspect or a component of a state government's revenue, so it is going to hold a very important ramification for all the state governments, since after the judicial pronouncement of this judgment, we will be able to clearly understand that whether the state governments will be able to bolster their revenue by levying taxes on the industrial alcohol or not. Now, coming to the important aspects of this case, as we know that Constitution of India has created the 7th schedule, which very clearly and objectively demarcates the various matters on which the two levels of government, that is the center and the state government, can legislate. So we have 3 lists. First is union list, second is state list and third is concurrent list. Union list comprises of all those matters on which the union government is empowered to create legislations. Similarly, the state list are comprising of those matters on which the state government can make legislation. And thirdly, the concurrent list on which both the center and the state government can make legislations. However, whenever on a particular matter present in the concurrent list, if a law exists by both the union and the state government, it should be noted that the state government's laws should not be repugnant to the provisions of the central government. Now, since we are discussing the primary agenda of industrial alcohol over here, we need to determine that what does the Constitution's 7th schedule say about the industrial alcohol? And that is what we are going to discuss over here. So, there is a entry number 8 in the state list which provides the power to the state government to regulate various facets related to the intoxicating liquors. Now, this is one of the biggest bone of contention in this proper case. Why? Because ultimately how this intoxicating liquor is different from industrial alcohol. So I would like to tell you students a very simple concept over here, that industrial alcohols are primarily 100% pure, either ethanol or methanol. However, when these industrial alcohols are firstly diluted and secondly denatured with the help of certain chemicals which make these industrial alcohols unpalatable or non-potable, that is not fit for the consumption of human beings. However, under the entry 8, these intoxicating liquors are meant for the consumption of human beings, and this is the chemical differences between the intoxicating liquors and industrial alcohol. However, the chemical differences does not make or provide any legal difference to it. So this is one of the major bone of contention which the Supreme Court is going to deliberate on it. And the second bone of contention which forms the primary agenda with respect to this case is that we are going to discuss in the coming section. So under the entry 52, the Constitution of India provides Parliament a very important power, that Parliament may by law provide the power to the union government to regulate any industry. So either it can be sugar industry, it can be industrial alcohol, etc. Okay. And thirdly, in the concurrent list, one very important entry which is of concern to us with respect to this particular case is the entry number 33, which again provides a power to the Parliament to provide power to the union government by means of a law, so that the union government can control any product of an industry if it is lying under the public interest domain. And this is what is going to be the second bone of contention. How? So, utilizing the power which has been given to the Parliament under the entry 52 in the Union list, Parliament created a law by the name of Industrial Development and Regulating Act of 1951. Under the IDRA Act of 1951, there was one section by the name of Section 18G. Now, what is this Section 18G? So, the Section 18G provides the power to the union government to regulate the entire industry in realm of public interest. So, if the union government, according to the Section 18G, if the union government feels that in the pursuit of public interest or to provide or to cater to the larger public interest or public good, union government can take under its ambit the regulation of a particular industry. And this is the bone of contention which has arrived, because whenever union government is going to take the regulation of a particular industry, it might be a possibility that it might hamper the power of the state government also, which has been provided to it by the entry number 33. And this is what we are going to discuss in the coming slides, because similar kind of cases has come to the Supreme Court earlier also. That similar kind of regulations or the tussle between the center and state with respect to whether be it sugar or whether be it alcohol, it had appeared in front of Supreme Court. And this is what, through the precedences of those cases, we are going to understand how did we ultimately land to a 9-judge bench in the present times. So, has the Supreme Court considered this issue earlier? So you will be surprised to know that there are two very important cases which forms the precursor to this particular case that we are trying to study in 2024. And primarily the first case which forms a precursor to it hails from the era of 1956, and you can understand the legal complexity of this particular matter, that it goes back to 1956, hardly when India was 10 years old. So, in the Tika Ramji versus UP case, what had happened primarily is that, as we know, that for the sugar sector, the primary feedstock is sugar cane. And what the UP government had done at that point of time is that UP government had created a legislation to regulate the sales and distribution of sugar cane. Now, since UP government was trying to regulate it, and as we know that the sugar sector falls under the Section 18G of the Industrial Development and Regulating Act. So, naturally what had happened is that central government went to the Supreme Court and they challenged the UP government's legislation regulating the supply and distribution of sugarcane. Now, what was the opinion of Supreme Court in the Tika Ramji case? So, Supreme Court in this particular case upheld the legislative competence of the state government, so that it held that the UP government is in total right to regulate the sugarcane's distribution and sales or prices, because ultimately under Section 18G, central government is regulating the sugar sector and not the sugar cane. So just that sugar sector lies in the section 18G. It does not give the power to the central government to regulate its feedstock, and that was the primary position of the Supreme Court. Now, what had happened after 3 decades, in the year of 1989, one very important case came to the fore with respect to the Supreme Court itself. Again, it was a constitution bench, and a larger bench, that is a 7-judge bench was there, and the case's name was Synthetic and Chemicals versus the State of UP. Now, in this case, what had happened is that Supreme Court opined that under the entry 8 that we discussed in the previous section, that under the entry 8 of the state list, state government is having the legitimacy to control only the intoxicating liquors and not the industrial alcohol. And industrial alcohol lying in the section 18G of the Industrial Development and Regulating Act, it will ultimately fall under the ambit of central government and not the state government. So, to highlight it again, the Supreme Court in the Synthetics and Chemicals versus State of UP, it held that under entry 8 of the state list, state government is competent enough to levy only on intoxicating liquors and not on industrial alcohols. Okay. However, the same Supreme Court held that under section 18G of the Industrial Development and Regulating Act, since industrial alcohol sector is listed in that particular section, it is the primary competence of the central government to make laws and regulations with respect to the industrial alcohols. However, there was one very important catch over here. And what was that particular catch? Is that what is the correlation between intoxicating liquor and industrial alcohol? Now, we will be surprised to know that addiction with respect to alcohol is so much that the notorious or the antisocial elements, they take the industrial alcohol and try to blend it in such a way that it can be consumed by the humans in certain proportions, and this leads to a very important term called surrogate alcohol. And ultimately, since the industrial alcohol, it comprises of ethanol which can be consumed by human beings. However, the industrial alcohol also comprises of methanol as well, which is extremely toxic and poisonous for the human beings. And when this industrial alcohol containing methanol, by vicious loops or channels, when it lands to the the consumers of this illegitimate alcohol by the name of surrogate alcohol, it leads to a lot of physical and human casualties or deaths as well. And this has become a pain for the state of Uttar Pradesh, and not only for the state of Uttar Pradesh, for a lot of states still at this point of time also. And that is why the state government of UP at that point of time wanted to regulate the industrial alcohol so that the industrial alcohol is not getting transferred or transmitted or converted into an intoxicating liquor. So through that thing, when we look at these two judgments, we are able to see that the reasoning or the arguments of the Supreme Court are contrary with respect to both these judgments. At one point in the Tikaramji case, the Supreme Court held that the product or the feedstock or the byproduct of that particular industry, that is the sugar, so sugar cane will fall under the regulatory competence of the state government. However, the same logic or the reasoning was not applied by the Supreme Court in the judgment which was given after 3 decades and by a larger judge bench. And this was gone unnoticed till the year of 1999. So what had happened in the year of 1999 is that UP government again tried to basically issue a notification and levying a 15% fee for the distribution or sale of industrial alcohols. So naturally, as the legal jurisprudence had or the legal precedents had, so all the motor oil and other such kind of industries which were using the industrial alcohol, they went to the Allahabad High Court, and ultimately the Allahabad High Court, it basically nullified the notification which was issued by the UP government. And now this UP government Again, after having their petition disqualified by the Allahabad High Court, they went to the Supreme Court. And in the year of 2007, one very important facet came to the Supreme Court's observation, that it noticed that when the Supreme Court's 7-judge bench were taking the judgment of synthetics and chemicals versus the state of UP, the important legal precedents which was developed by the Tikaramji case was not brought in front of this particular bench, that is a 7-judge bench, and which led to a question of bad law, and that is why Supreme Court decided to refer this particular case of law or the question of law to a 9-judge bench, which the Supreme Court is now listening while we are discussing this particular topic. Now, ultimately, when we'll be done with this particular, when the Supreme Court will be done with respect to its judgment, a lot of clarity will be achieved, not only to the central government but also to the state governments. And since, as we know, that industrial alcohol and alcohol which are fit for the human consumption forms for a great sources of revenue for the state governments as well, and that is why this judgment, which still has to be pronounced by the Supreme Court, holds a very, very important place in India's political history. Now, India is an extremely diverse country, and the diversity does not only belong to the region, geography, caste, ethnicity, races, etc. But this diversity that India holds or its culture holds percolates to the traditions, customs and rituals that we follow. And one of the most important and fascinating aspect of India's diversity with respect to the traditions and customs is how different communities which are present in India actually go for the divorce or nullify their marriages. And in this particular topic, we are going to discuss and we are going to learn exactly the same facet of how the women of our Muslim communities take divorces from their husbands. And one of the important aspect of divorce, or one of the form of divorce in that case, is Khula. So what we are going to study is that the right to unilateral divorce which is given to women through Khula. Now, coming to the context, the first context being the Supreme Court of our country will examine a very important and a very critical judgment which has been pronounced by the High Court of Kerala with respect to the women's utilization of the Khula way of divorce. And secondly, as we know that our ace tennis player Sania Mirza recently parted ways with her cricketer husband Shoaib Malik with the help of Khula way of divorce, and that is what we are going to discuss. What do we actually understand by the term Khula, and what are the other ways of divorce or the methods of divorce which are available to the Muslim women of our country with which is compliant with their personal laws. So what do we understand by the term Khula? So Khula is a method. Khula is a method of divorce which is available to the Muslim women, and it is unilateral in nature. That is, the right, it is a right given to the Muslim women to take divorce or to ask for divorce from her husband even without the consent or agreeable nature of the husband. And this is one of the extrajudicial forms of divorce which are available with respect to the Muslim women of our country. And the 2021 High Court ruling of the Kerala High Court, it basically provided that it is the inviolable act, it is the inviolable right of the Muslim women of our country to demand Khula without the consent of their husband. Now, what are the other different forms of like divorces which are available to the Muslim women of our country, which are extrajudicial in nature? And what do we understand by the term extrajudicial? Extrajudicial means that without the intervention of courts, that a Muslim woman should not have to go to a court to seek divorce from their husband, and they do not have to comply by the Indian laws and the very tedious processes of the courts to seek that particular divorce. Now, apart from the Khula, there are three very important other modes of divorce also available to the women. That is, first being talaq-e-tafwiz. Now, as we know that the conception of marriage in Islam is based on contracts. So, marriage is seen as a contract between a spouse and a woman. So, ultimately what happens is that before the marriage, both the boy and the girl, they try to decide the terms of the contract which they are going to follow or obey while the marriage is working. So, whenever a woman feels that the terms of the contracts is not being followed by the husband, so a woman can definitely seek divorce from her particular husband. The second being mubarat. Mubarat means that here the divorce is consensual, that is through mutual consent. That whenever there is a situation that both husband and wife feel that this marriage is not working and is not amicable and filled with a lot of like disturbances, then both the husband and the wife in a mutual way can go for mubarat mode of divorce. Thirdly being the fusk. Fusk means it is a mode of divorce which is available to the women with the help of a mediator. The mediator in this case can be a court of law, and secondly quasi-judicial religious bodies like Qazi. And these are the major forms of or the modes of divorces which are extrajudicial in nature and has been provided to the Muslim women of our country. Now we'll try to see what does the personal laws of Muslims say about the forms of divorces which are present with the Muslim women. Now, before we actually go on and discuss the Muslim personal law, we will have to briefly discuss what do we actually understand by the term personal law. So, personal laws are nothing but a set of laws which govern very important facets of a particular individual's life. And what do these facets comprise of? It comprises of birth, succession, marriage, divorce, kinship, and inheritance. These are the important facets of an individual's existence which are basically regulated by the personal laws. And since India is a very multicultural society having different sort of religions coexisting at the same place and at the same time, you will be surprised to know that almost every religion have their own set of personal laws and they are regulating the behaviors of their individuals or the denominations of that particular religion with respect to how they marry, at what age they can marry, how they can go for divorce, how they are going to decide their succession, who is going to take the inheritance of their parents. Such kind of facets are being decided by the personal laws of that particular religion itself. Now, with respect to the Muslim community of our India, there is a particular act by the name of Muslim Personal Law Shariat Application Act of 1937, which basically provides for the various kind of marriages and divorces or the forms of divorces which are available to both the husband and the wives separately. Now, the first important point which we have to note over here under the Muslim Personal Law Shariat Application Act of 1937 is that the Section 2. The Section 2 provides that this particular Shariat Act basically recognizes all the judicial and the extrajudicial forms of divorces which are available to the women under the Quran and other religious scriptures except the fusk that we had discussed in the previous section. And similarly, there is one Section 5 which provides that for the dissolution of a marriage, a woman can seek the assistance of a court of law. Now, these were the basic sections which basically regulated the forms of divorces and the procedures that a woman has to follow to seek divorce. Now, as we know that the laws is just one of the element which controls the behavior of women with respect to the Muslim community. However, there are other social customs as well, and based on different Islamic school of jurisprudence of law, so there is one Hanafi school of Islamic law which says that although the Muslim women are being provided a legal route with respect to the court of law, the Hanafi school discourages the Muslim women to go to the courts and seek for divorce. So to actually curb that diversity of opinions and diversity of laws which exist in the realm, there was a particular act by the name of Dissolution of Muslim Marriage Act 1939 was formulated, and the major agenda for promulgating this particular act was to bring in more clarity with respect to what kind of rights do the Muslim women actually have when they want to seek divorce from their husbands. Now, this act particularly did two very important things. Firstly, it gave recognition to all forms of extrajudicial modes of divorce which are given to the Muslim women under the Quran or major important religious scriptures. Secondly, it basically annulled or repealed the section 5 of the Shariat application law, and it replaced it with the section 2 of this particular act, which provided the various grounds on which the Muslim women can seek divorce from their husbands. Now, what are the various grounds that are there, which the section 2 of the Dissolution of Muslim Marriage Act 1939 has provided? So, the first being cruelty, desertion, imprisonment, impotency or violence, etc. Now, what the Supreme Court is trying to examine with respect to this particular High Court ruling is that first, as we saw earlier, that whether the right of a woman to seek Khula from their husband is absolute and she does not need to provide any form of reason or reasoning to their husband, first. And secondly, as we saw that with the Act of 1939, it basically repealed the section 5, which had provided the Muslim women a legal route to go through the courts to seek the divorce if the religious functionaries are not performing in the right way. So the Supreme Court is going to examine this facet of the law as well, that whether by passing of the Dissolution of Muslim Marriage Act of 1939, did it annul the section 5 or the legal course of route which was available to the Muslim women. And these are the primary agendas which the Supreme Court is going to deliberate as soon as the Supreme Court is going to provide the judgment. I will request you to kindly pause your screen so that you can solve this particular MCQ. Now, as we know that the Lok Sabha elections to constitute the 18th Lok Sabha is underway, the Election Commission of India has come up with a very innovative and technological solution to streamline the election management process with the help of SUVIDHA application and web portal. So what is this? So what is SUVIDHA application and web portal? So as we know that with respect to the very competitive electoral politics and the nature of electoral politics in our country, when the elections are going on, all the political parties and the candidates which are participating in the election are focusing their entire energy, resources and time in campaigning to get more and more votes, to reaching out to the various electors and to win ultimately. And to hold the campaignings in the best possible way, every candidate has to seek a lot of permissions, whether permissions can be for helicopter, whether it can be for rallying, whether the permissions it can be for vehicle permit or pamphlet distribution, or whether the permission can be related to the loudspeaker permit. Now, as we know that this time of campaigning is extremely competitive, and the political parties and the candidates cannot afford to lose time running after various governmental departments to seek the permissions. And it can also be a possibility that the ruling party or the ruling government will favor their own candidates only while providing such permissions. And it might be a possibility that the opposition parties might find it extremely difficult to seek such permissions from the government, and therefore to create a very free and fair and equal opportunity environment for all political parties, Election Commission of India has come up with a very important technological innovative tool by the name of SUVIDHA portal or app. Now, what is this? So ultimately SUVIDHA app is a single window portal which is available to both the political parties and candidate to apply for various permissions that they would be requiring to actually perform their campaigning activities. So as we already discussed the kind and the variety of permissions a particular candidate needs, so ultimately through a single window coverage, a political party or a candidate will be able to seek the permissions from various kind of governmental departments, and they do not have to run after every particular department to provide their particular permissions. Now coming to the features, one very important facet of SUVIDHA is that it is available over the both web and app format, that you can access its website as well and the application as well on your mobile phone. Secondly is that it functions on the principle of first in and first out, which basically limits the preferential treatment which could have been catered to the ruling party. The third important aspect is that whether the political party or the candidates, they do not have to go physically to all the governmental offices to seek permissions with respect to their particular domain. However, the entire political party or the candidates can just seek their permissions in an online format also. And lastly, since entire data is being aggregated and put on the portal, the various political parties and the candidates can actually track the the position of their permission status. Now, coming to what are the major benefits that we can actually accrue from the Suvidha portal. So, as we know that it's a single window platform for all the political parties and the candidates, it is going to save a lot of time, energy, physical and the financial resources of all the political parties and candidates, so that they can better use and channelize their energies in campaigning rather than navigating the maze of the red tapeism. Secondly, about the transparency and accountability. Now, as we know that the Suvidha app or the web portal follows the first in and first out principle. Ultimately, it is bolstering the transparency that ultimately who is going to put the request first, they are going to take the permission first, and there will be no preferential treatment vis-a-vis the ruling party or the opposition party. And that is why, since everything is transparent, the governmental officers who are actually looking after such work will be accountable, because every data is visible not only to the candidates and the political parties but also to the normal citizenry as well. The third important facet is that since the entire data will be available to the public and the civil society organizations can actually scrutinize that data and come up with very important conclusions with respect to what kind of campaignings are being done by what kind of parties. And lastly, ultimately it will try to create an environment of free and fair elections. With the help of the Suvidha app, Election Commission is committed to actually perform its constitutionally obligated goals of creating such an environment where every stakeholder, every political party and every candidate finds a level playing field so that they can reach out to the electors and get elected. Now, as we know that the elections are underway to constitute the 18th Lok Sabha for our country, and under that thing, all the political parties and candidates are vying to reach out to potential voter base, not only through the physical media, that is by coming to your localities or communities to do the physical campaigning, but they are also trying to reach out to the potential voter base through the social media platforms. And this is why it determines the importance of how the social media platforms are being regulated so as to provide equal and level playing field for all the political parties and the candidates. And this is what we are going to discuss in the coming slide. So recently, coming to the context, what had happened is that the X, which was earlier known as Twitter, it basically had taken down 4 various posts which were posted in the platform of Twitter after the takedown order by the Election Commission of India. Initially, the Twitter basically rejected the Election Commission of India that they will not take down the various posts which has been posted by the political parties. However, the Election Commission, when it reminded Twitter that it had been a signatory to the voluntary code of ethics for the social media platform, Twitter hesitantly agreed to the request of the Election Commission of India. Now, one very important facet we need to actually study over here is that why or what was the need for this voluntary code of ethics for social media platforms, and when did it emerge and how did it emerge. So, and in this sequence we are going to actually understand it, and the first being the why. So as we know that the internet and the various social media platforms, whether be it WhatsApp, Instagram, Telegram, Facebook, etc., it started flourishing and proliferating maybe after roughly 2017. And you will be surprised to know that in 2024, we have almost 85 crores of active internet users. And the first time that the Election Commission of India faced the challenges which were being faced by the social media platforms and the notorious use of the political functionaries within the social media platforms, it first came to fore with respect in front of Election Commission of India in the general election of 2019. Because by the time of 2019, enough social media platforms had flourished and a lot of people, roughly to the tune of 50 crores, people were actively using and engaging with the social media platforms, and this led to the Election Commission to actually turn their gaze towards how the social media platforms should be regulated, so that it should provide a level playing field. It should provide a level playing field not only to the larger political parties or very famous political candidates, but also to the smaller political parties and other stakeholders of Indian political system, that is the media and civil society organizations as well. And that is why in 2019, Election Commission of India, under the chairmanship of its Deputy Election Commissioner Ramesh Sinha, they constituted a committee which was basically provided the task to deliberate on the idea that how should the social media platforms be regulated so that it should provide a level playing field, and it should provide with such an electoral environment so that it will result into a free and fair elections. And after a lot of deliberations, it was decided, this committee basically deliberated with not only with the political functionaries, but with also with the pressure groups by the name of IAMAI, that is Internet and Mobile Association of India, which is a pressure group working in the segment of mobiles and internet. And this IAMAI and the other social media platforms, under the direction of EC, they came up with a voluntary code of ethics. And as we know that this code of ethics is basically tells us that what should be and what ought to be. So this voluntary code of ethics is providing how the larger designs of the social media platforms should be there so as to provide a very smooth and a very fair electoral environment. And why voluntary? Because ultimately one of the best ways to regulate media is through self-regulation only. One mode could have been there with the government of India, that it could have directly regulated the social media platforms with the help of certain legislations, but going by following a very liberal path, Government of India and the Election Commission of India chose to go for a voluntary code of ethics, which almost all social media platforms had actually signed in the year of 2019, and which is going to be followed for the coming elections also. And the same voluntary code of ethics is being followed in the elections of 2024 that is underway right now. But what are the major components or the salient features of this voluntary code of ethics? So the first important point with respect to the voluntary code of ethics is that the social media platforms should take voluntary information, education and communication campaigns so as to inform all the voters about what kind of candidates are being placed by various kind of political parties, so that all the voters can take informed decisions. That is the primary agenda of voluntary IEC campaigns. Secondly, all the social media platforms, they basically join to collaborate on a point that as soon as the physical campaign ends, before the start of the voting, before 48 hours, similarly in line with that thing, 48 hours before the voting starts, all the political ads or campaigning will also be stopped or taken out of the social media platforms as well. Thirdly, all the social media platforms basically narrowed down to that they will create a dedicated grievance redressal channel so that it will be very harmonious for the Election Commission of India to coordinate with various kind of social media platforms, and like the Election Commission of India should not find it difficult to actually raise concerns or grievances with respect to the functioning of the social media. Fourthly, that the social media platform should provide transparency in the form of paid ads. So it should use different technological tools like watermarking and segregating certain ads, so that the consumers who are utilizing the content which is being transmitted through the social media platforms, they actually understand what is a paid advertisement and what is an actually editorial. And lastly, that all the social media platforms should process valid legal orders which are being provided by the Election Commission of India within 3 hours. So Election Commission of India, whenever they are providing any legal order under the section 126 of RPA, the social media platforms are obligated to take down the content which has been flagged by the EC within 3 hours since the Election Commission of India has provided it. Now, these are the major important salient features which are there in the voluntary code of ethics for the social media platform. Now, as we know that the internet penetration in our country is growing every day, and every day lakhs and lakhs of people are participating in various kind of social media platforms, and political functionaries, political parties and candidates are utilizing and leveraging the presence of digital citizenry over the social media platforms to actually take ahead their propaganda and to win the elections. And that is why it is extremely important to regulate and to design the various functionalities of social media platforms in such a manner that ultimately it results into such kind of electoral environment which provides a level playing field not only to the larger political parties but also to the smaller political parties, whether be it an opposition or ruling somewhere, or the media or the civil society organizations. Sports hold significance for us not only in the realm of physical health and recreation, but it serves greater purpose like self-actualization, community building and breaking stereotypes. And in this section, we are going to discuss how Special Olympics Bharat is actually trying to achieve these goals. So coming to the context, why we are studying the Special Olympics Bharat at first place. So recently, the Special Olympics Bharat conducted elections throughout the Tamil Nadu to elect its state units. Now, to come to the basic nitty-gritty of the Special Olympics Bharat, we first need to actually deconstruct what is Special Olympics International, of which Special Olympics Bharat is just a chapter. Okay, so Special Olympics International is a global movement for promoting a more inclusive society by including people with intellectual disabilities, by leveraging the power of the sports and education, and to actually provide such an environment for the persons with intellectual disabilities so that they can actually participate in normal day-to-day societal activities through the power of sports. And that is what the Special Olympics Bharat is also trying to achieve, that vision. So what is the proper mission which the Special Olympics International is trying to follow? So the first important mission which the SOI or the Special Olympics International is trying to follow is to provide a year-round training and competitions for the persons with intellectual disabilities. Now, you will ask this question that what do we understand by the persons with intellectual disabilities? Various psychological and psychiatric literatures has suggested that ultimately the persons with intellectual disabilities can be defined under these 3 categories. So firstly, these are those persons who have IQ or the intelligent quotient less than 70. Secondly, due to the poor cognitive development or the brain development, these people tend to have poor social and self-care skills, like they are not able to generate better linguistic skills as well. They are not able to take care of themselves with respect to the motor skills, that how do they walk, how do they talk, etc. And thirdly, if such kind of conditions manifest before when a person achieves the age of 22 years. And this is how we are trying to define the persons with intellectual disabilities. And the Special Olympics International has the primary goal and the mission and the vision to create a more socially inclusive order so that these persons with intellectual disabilities can participate in various activities which the society is offering. And how does the Special Olympics International is trying to do that? By going for a 3-pronged mission. Firstly, to provide a year-round training and competitions to these persons with intellectual disabilities so that they are able to train themselves in various kind of sports. Secondly, by conducting various kind of sporting events, the SOI or the Special Olympics International is providing opportunities to the persons with intellectual disabilities to actually participate in various kind of sporting events which are being conducted by SOI. And you will be surprised to know that SOI is conducting almost 30 plus sporting events just in line with how such kind of sporting events are being taken place in normal Olympics as well. And thirdly, one of the major important mission which SOI is trying to follow is to break the stereotypes, that we have to train our people and we need to change the stereotypes which is there in the mind of the society, that we need to think beyond the paradigm of ability and disability, that a person has to be capable to take or to participate in various activities of social life, not on the based on what they can do or what they cannot do. And this is the major mission which SOI is trying to follow, so as to break down the various stereotypes which are prevalent in our society. And the same mission is trying to impose in our country through the Special Olympics Bharat chapter of the Special Olympics International. And the same mission is being trying to be implemented by the Special Olympics Bharat as well. This Special Olympics Bharat is being recognized as a national sports federation by our Ministry of Youth Affairs and Sports. And let us try to see what are the major objectives which this Special Olympics Bharat is trying to achieve. So the first part is, one of the major important problem which the persons with intellectual disabilities face is the mainstreaming, that the persons with intellectual disabilities, since their cognitive function is improper and their growth and development is slow as compared to the other people, they tend to fall out of the schooling systems or educational systems. And one of the major objective which the SOB or the Special Olympics Bharat wants to achieve is through the holistic development of PWID by various trainings and developing such kind of curriculums, so that the persons with intellectual disabilities do not go out of or fall out of educational institutions and they continue to study in normal schooling systems. Secondly, to sensitize people around them. One of the major problems which persons with intellectual disabilities face is that the persons whom they are surrounded with, whether be it peers or teachers, are not aware or sensitized with respect to what kind of problems these people are facing. And that is why sensitization of teachers and peers form a very important component which the Special Olympics Bharat is trying to achieve. Third point is sports training, going directly with respect to its mission. That is, it is providing sports training to the persons with intellectual disabilities by providing various kind of infrastructural, whether be it physical or human, so that these persons are promoted and encouraged to take part in various sporting activities. And lastly, that the Special Olympics Bharat is trying to coordinate such kind of sporting events in our country which are at par with the Olympic standards. And you will be surprised to know that Special Olympics Bharat is also organizing 20 plus such track and field events for the athletes which are there having the intellectual disabilities. And with respect to the kind of work that Special Olympics Bharat is doing, it is trying to create a just social order so that it is very inclusive in nature, and the society is structured in such a manner that our disabilities and abilities, the boundary between that is getting blurred. Of late, India's glory and majesty has increased across the international sporting events, with our more and more athletes getting various medals in various sporting events like Olympics and Asian Games. And the institution which is responsible for managing the athletics in India is the Athletics Federation of India. And in this article, we are going to discuss why it was established and the major and crucial objectives which are being performed by the Athletics Federation of India, or AFI. Now, what is the context that we are trying to read about AFI? So recently, AFI disaffiliated almost 16 district state units because these units were incompetent enough, or they could not send the teams to the national level junior athletic meet. Now, ultimately, before we go on and discuss the various facets with related to the AFI about its objective and its establishment, we will like to briefly discuss about what do we actually understand by the term athletics. So athletics in a way is a set of sporting activities which comprises of activities like running, walking, jumping or throwing. Just to give you an example, there can be various sporting activities within the category of running. For example, 100-meter sprints or 200-meter sprints or 400-meter relays. For walking, there can be another set of sporting activities like speed walking. For jumping, there can be various kind of sporting activities like long jump, high jump, pole vault. And for throwing, as we already know, that the most famous as of now the sporting event because of Neeraj Chopra is javelin or shot put. And to regulate the management or how the athletics is going to be governed in India, AFI or the Athletics Federation of India is the apex body which actually governs, manages and regulates the various athletic activities which are being taken place in our country. Now, Athletics Federation of India, hereafter AFI, was established as a NG, a non-governmental or a non-profit organization in the year of 1946 after being registered as a societies under the Societies Registration Act of 1860. One of the major important aspect of Athletics Federation of India is that it has to manage its 30 different affiliated state units which actually administer the various activities the AFI is going to take within their particular states. So for example, almost 30 states and UTs of our country are affiliated with the Athletics Federation of India with their own state federation for athletics. Now, the third important aspect which we need to note over here is that the Athletics Federation of India is affiliated with very important international bodies which regulate and create norms for the governance of athletics across the world. To name some, it will be International Olympic Association, it will be World Athletics, and it will be Amateur Athletics Association. These are the three major important organizations which are of international in nature, which governs and regulates and creates standards. Now let us try to see the various objectives for which the AFI had been established. So the first fundamental objective for which AFI had been established was to promote and encourage athletics in India. As we know that India is a very sporting country. However, only cricket has got the imagination or collective imagination of our society, and one of the primary responsibility of Athletics Federation of India is to restructure the imagination or the sporting imagination of our society so as to create more acceptance and space in the public psychology so that more and more people of our society participate in various kind of sporting activities which come under the realm of athletics. So to promote and encourage athletics in India, Athletics Federation of India goes for various routes. For example, it goes for promotion in various social medias. It goes for promotion and advertisement across the various mass media platforms. Secondly, it goes for establishment of various sporting meets. Not only at the national level but also at the national, state and district level. The second important point is that if we need to percolate the athletics to the grassroots level of India, one singular body sitting in the national capital of Delhi will not be able to take that value and take that spirit of athleticism across the society. And that is why the second primary objective of AFI is to organize, control and regulate the administrative activities and to manage athletics across the states of our country as well. And as we already have noticed that almost 30 states and UTs have been affiliated to the Athletics Federation of India, whereby the AFI provides various kind of technical, financial and infrastructural supports to the affiliated organizations within that particular state. Third is providing infrastructure. As we know that India is facing a dearth of sporting infrastructure with respect to grounds, track fields, nice and state-of-the-art equipments. And one of the primary objective of AFI is to provide infrastructure not only to the sporting candidates or to not only to the athletes but also to different state affiliated units as well. And this infrastructure will comprise of two elements, that is physical infrastructure and human infrastructure. So it will be the objective of AFI to provide proper coaching facilities, proper literature review so that the sporting athlete should be able to get exposure to the world-class facilities of coaching and whatever literature is being developed in that particular realm. Fourth is financing. One of the most important facet why India is not able to come at par with other developed and developing countries in the athletic realm is that we do not have the proper financing of the sporting events, and that is why one of the primary objectives of AFI is to provide financing to not only to athletes but also to the state governments and state institutions which are affiliated to AFI, so that these finances can be used for development of infrastructure and development of organization and establishment of various affiliated state units of AFI. Fifth important point is that it has to comply, the AFI has to make sure, AFI has to ensure that the state units which are affiliated to AFI are complying with the international rules and regulations which have been codified by various international organizations working in the realm of athletics, like International Olympic Association, like World Athletics, etc. And lastly, you'll be surprised to know that it is the Athletics Federation of India which manages and selects the team or the contingents of the team which represents our country in international sporting arenas like Olympics, Asiads, Asian Games, etc. And now, if we really want to increase the power of India through the soft power route, sporting is a very potent tool so that we can reach out to the world and project our image as a very productive and efficient sporting nation. India being a multi-religious country, Muslim community forms the largest minority group in our country. Despite being the largest minority group, Muslim community largely is under the shackles of poverty, unemployment and various kinds of deprivations. Time and again, the demands have been raised from outside and inside of the community so as to provide the Muslim community with the benefits of affirmative action and reservations. And every time, whenever there is an election, there is an increase in this demand to provide the quota or the reservation to the Muslim communities. And the same demand has been raised while we are undergoing the elections to constitute the 18th Lok Sabha. And this is what we are going to analyze in the coming slides. So what is the context to it? So recently, Prime Minister Modi ji was addressing a rally in the Tong district of Rajasthan where he raised out a very critical issue. He accused Congress that the Congress is taking away the reservations which was mandated for the scheduled caste, scheduled tribe and OBC communities of our country, and the Congress is scheming to take away that reservations from it and trying to give away that reservation to the Muslim community. And primarily, Prime Minister raised a very important contention that can the reservations be linked to the religion of a particular community? And this is what we are going to analyze in this particular section. So the first important point which should come to our mind is that under the existing constitutional setup, can Muslim communities, can they be provided reservations? And this is what we are going to discuss in this section. So ultimately, the reservation comes from two major important articles, Article 15 and Article 16 Clause 4. And Article 16 Clause 4 of the Constitution says that the Government of India can provide the backward classes any reservation if they feel that they are inadequately represented in the services under the state. So ultimately, this backwardness can be linked to a particular religion if there is a substantial data which is pointing to the backwardness of the particular class. Now, what do we understand by the term class? So class is a distinct group of people. Class is a distinct group of people sharing similar socio-economic and political status. And it might be a possibility that Muslim community as a whole is coming under the same class. This is the view of various legal experts and the Supreme Court advocates. And that is why the National Commission for Backward Classes had come up with several indicators which covered the socio-educational, economic and political parameters through which the NCBC was trying to judge the backwardness of a particular community. And it might be a possibility that the Muslim community as a whole is not able to qualify the minimum threshold criterion which the NCBC has put in the realm of socio-educational, economic and political criterion. So that in that case, the entire Muslim community can be labeled as a backward class, and which makes it eligible to reservation under the various clauses of section Article 15 and Article 16. And this is what has happened with respect to Article 16 clause 4 also. Now, there was one such a committee which released its report which tried to understand the backwardness of the Muslim community in our country. And in 2006, it had released its report, and it was a starking revelation with respect to the social realities of the Muslim community. The Sachar committee report found that the entire Muslim community is way backward than the entire Hindu OBC group combined together. So, which basically necessitated that if the Muslim community is backward than the Hindu OBC, and the Hindu OBC is already availing benefits under benefits of the reservation under Article 16 clause 4, which makes it naturally logical so that the Muslim community can also avail benefits of the reservation under various articles of 15 and 16 clause 4. Now, when we know that the constitutional position is quite clear, and we already know that like if the Muslim communities can be categorized as backwards based on certain objective parameters of the NBC, now we'll try to see what is the status, or let us take a survey of what kind of reservations Muslim people are getting, or certain sects of Muslim people are getting at the central level and at the state level. So, let us try to check through the status of reservations of Muslim, not only at the central level but also at the state level. Now, as we know that the entire Muslim community is not getting the OBC categorizations within the central level. So, as we know that both central government and the state government maintains their own separate OBC list. So, central government provides for roughly 50 communities within the Muslim community the benefits of reservation under the OBC category, that is other backward classes communities. Now, similarly, what is the situation at the state government level? Now, there is a great degree of heterogeneity with respect to the kind of benefits Muslim community as a whole is accruing across different states. To help you understand with the help of an example, for example, Kerala is the first case, and Kerala basically provides reservation benefits under the OBC to the entire Muslim community. And they are being getting benefit of roughly 10% reservation in the educational and the jobs under the state government. The case is little different in the case of Tamil Nadu, where almost 95% of the Muslim community is getting benefits of the OBC reservation, and they have been mentioned under the state OBC list. In case of Bihar, again there is a case of heterogeneity over Bihar. In Bihar has categorized the entire group of people who fall under the OBC under two categories. First category is backward category, and second category is most backward classes. Okay, and majority of the Muslim communities fall under the most backward classes category within the other backward classes. So ultimately, Bihar is also providing a great degree of reservation to the entire Muslim community. The same is the case with Karnataka, which is providing the entire Muslim community reservations and a sub-quota of 4% within the OBC category. And lastly, in the speech which the Prime Minister Modi ji had delivered in the Tong district of Rajasthan, he had taken the case, he had accused Congress of actually taking away the reservations from SC, ST and OBCs and giving it away to Muslims. And for a case study, he had taken the example of Andhra Pradesh, and he has highlighted in front of the people that how Congress government is trying to do a pilot project in Andhra Pradesh with respect to giving reservations to Muslims by taking away the reservations from the categories of SC, ST and OBC. So was the argument made by Prime Minister correct? And that is what we are going to examine in the next slide. So let us try to understand the case study of Andhra Pradesh with respect to their efforts to provide reservations or the benefits of affirmative action to the Muslim community. Now, one important point we need to note over here is that Muslim community comprises of 9% of the population of Andhra Pradesh, and usually right now there are certain sects within the Muslim community like Dude Kela, Dadaf, Nurbash, etc., who are getting the reservation benefits within the state of Andhra Pradesh. So Andhra Pradesh is not classifying the entire Muslim community as backward class. However, what Andhra Pradesh has done is that out of the entire Muslim community, it has taken out certain sects or certain sections of the Muslim community, and then it has categorized it to be backward in nature. And after declaring that sections or sects backward in nature, they became available and they became ingrained in the state OBC list. Now, ultimately, the demand is constantly rising in the state of Andhra Pradesh so as to enlarge the bracket of sections of Muslim community within the state OBC list. Or to put in a different way, that there is a very endogenous demand in the Muslim community in Andhra Pradesh that they want the entire Muslim community, just like it had happened in the case of Kerala and Karnataka, to be included under the state OBC list. And Karnataka and the Andhra Pradesh government, following the same thing, had tried to made certain efforts in the similar directions. So it started in the year of 2004. What had happened is that in the year of 2004, because of the constant demand from the Muslim community, Congress government at that point of time, they decided that it ordered the Commissionerate for Minority Welfare to study the socio-economic backwardness of the Muslim community. And when the Commissionerate for Minorities Welfare, they ended their study while studying about the various backward parameters of the Muslim community, they recommended the government that the Muslim community is quite backward and these communities should be provided a 5% reservation outside the OBC. Now what had happened, then the Karnataka Andhra Pradesh government at that point of time followed the suit and provided 5% reservation to the Muslim community. However, this judgment, this notification of the Andhra Pradesh government was struck down by the Andhra Pradesh High Court. Why? Because Andhra Pradesh High Court noted that, okay, we are agreeing to the fact that Muslim community as a whole is quite backward and there has to be an effort of positive affirmative action towards the Muslim community. However, what Andhra Pradesh High Court noted, that due process was not followed, that the State Backward Classes Commission was not involved. So that is why Andhra Pradesh High Court basically nullified the notification giving 5% reservation to the Muslim community, because High Court noted that the State Backward Classes Commission was not included while studying about the socio-economic deprivations of the Muslim community. So, as a natural consequence, in 2005, Andhra Pradesh government constituted the State Backward Classes Commission and gave it the task to understand the deprivations and the backwardness of the Muslim community. And ultimately, it came to the point that the State Backward Classes Commission again recommended 5% reservation for the Muslims outside the OBC quota. So, and as the SBCC had also recommended, the Andhra Pradesh government basically followed the suit and provided 5% reservation to the entire Muslim community. However, the problem was that this time again Andhra Pradesh High Court again nullified this order. Why? Because after having given the 5% reservation to the Muslim community, it breached the 50% cap which was established by the Indira Saune judgment. So the recent move of 2005 by the Andhra Pradesh government to provide 5% reservation, it breached the 50% cap which had been established by the Indira Saune judgment, and that is why again this sort of thing happened, that Andhra Pradesh High Court nullified the nullified the notification by the Andhra Pradesh High Court. However, now as soon as the Andhra Pradesh High Court again nullified the notification which was issued by the Andhra Pradesh government, so this judgment was again appealed in the Supreme Court, and the Supreme Court is still hearing it, and there has to be hearing which has to take place with respect to this regard. And as we know that Muslims forms the largest minority group in our country, and we need to know that majority of the Muslim communities is under the shackles of deprivation, poverty and unemployment, as it has been highlighted by various committees, whether be it of national and international nature. And it will be of great relief for the Muslim community if we can come to certain very conclusive evidence with respect to how much and at what time the Muslim community should be provided reservation. As we know that the elections are underway to constitute the 18th Lok Sabha for our country, imagine a peculiar situation where there is only one contesting candidate for a particular constituency and there are no other contestants. In that case, it is quite logical and natural that the only contesting party will win. Imagine a situation that you are the person who is only participating in a race of a 100-meter race where there is no opponent. So you are bound to win that particular race. And similar thing has happened in the case of Surat constituency, where the BJP candidate by the name of Mukesh Dalal has been declared winner even before contesting the elections by the Election Commission of India. So few important developments had taken place. That is why the Mukesh Dalal, or the candidate from the BJP, had been declared the winner for the Surat constituency, and that is what we are going to discuss in the coming slides. So to discuss, we need to first understand the various legal frameworks which actually governs the procedure and the processes related to the filing of nominations for various candidates. The important legislation in focus over here is the Representation of People's Act 1951. Hereafter we will call it RPA 1951. So the section 33 of the RPA 1951 provides the norms to regulate the filing of nomination processes for various candidates for both the parliament and the state legislative elections. Now, according to the section 33, the nomination process starts with when the ECI, or the Election Commission of India, issues notification informing all the political parties that the nomination process has started for that particular phase of the elections. Now, as soon as the Election Commission of India releases the notification, the returning officer of every constituency following this notification also releases again, or also issues again notifications informing the various candidates who are going to contest the election from that constituency about what is the requirement for the nomination file, when they can, in what format they have to actually submit their nomination, till what time they can submit their nomination, and at what place they can submit their nomination. So a notification is issued by the returning officer also, carrying all the various details which all the candidates they have to follow. Now, ultimately, the second important question that we need to discuss over here is who can file the nomination and how it has to be done. Now, ultimately, the section 33 clause 7, section 33 clause 7 of the RPA Act 1951, it provides that any person who is duly qualified or duly eligible to contest elections for the Lok Sabha can nominate or can file their nominations in up to 2 constituencies across India, and it is not necessary that they have to file their nominations in the particular state where they have been registered as an elector. For example, to understand it better with the help of an example, consider the case of Rahul Gandhi. So Rahul Gandhi is registered as an elector in the state of Delhi. However, according to section 33 clause 7, it allows and it empowers Rahul Gandhi to file his nomination from 2 places. Either it can be Wayanad or it can be Raebareli, which is not his home state or where he is registered as an elector. However, one important point we need to note over here, that any candidate who is going to file his nominations, it has to be undertaken by a proposer. And the law suggests that wherever the candidate is trying to file his nominations, the proposers has to be belonging from that particular constituency itself. And if the proposers and if the candidate is belonging to a recognized party, it will require only 1 proposers, and if the candidate is belonging to a non-recognized party, it will require minimum 10 proposers. And again, the section 33, it provides for the what kind of valid requirements are there which has to be followed by the candidates so that their nomination file should not get rejected. So the section 33 clause 3 again provides that the nomination which the candidate is filing should contain very clear-cut signatures and clear-cut names and electoral roll numbers of the candidates and the proposers itself. And as soon as a candidate is done filing his nomination in front of the returning officer which has been designated for a particular constituency, then comes the role of section 36 of RPA 1951. So as soon as a candidate files his nomination paper, the next logical consequence is that the returning officer is going to scrutinize the legitimacy of the nomination paper filed by the candidate. And while scrutinizing the nomination papers filed by a candidate, the returning officer looks for the various kind of legitimate data sets which are available in the nomination files. For example, whether the candidate has provided the correct name, signature and electoral roll numbers of the proposers and the candidate itself. And once the returning officer finds any anomaly in providing the right signature, or they find any kind of dubious information which is present over there in the nomination document, or if the returning officer finds that the candidate has filed the nomination but not in the desired format, Section 36 of the RP 1951 empowers the returning officer to actually nullify the candidature of that particular contestant. And this is exactly what has happened in the case of Surat constituency, where the Congress's candidate, that is by the name of Nilesh Kumbhani, his candidature was basically declared null and void by the returning officer of the Surat constituency. So, to give you a basic detail, this Nilesh Kumbhani, who was the candidate for the Congress party, he had filed 3 nominations so as to increase his chances of getting his nomination papers selected or better scrutinized. However, what had happened is that BJP, certain members of the BJP, they complained to the returning officer claiming that the Nilesh Kumbhani's official affidavit is not containing the legitimate data and they are containing dubious data. So what had happened is the returning officer of the Surat constituency, he called up the proposers of Nilesh Kumbhani to the office so as to examine and scrutinize the fact. However, the proposers of Nilesh Kumbhani failed to appear in front of the returning officer in due course of time, and this led to the returning officer to nullify the candidature of Nilesh Kumbhani. And this is what happened, that as soon as the major candidate Nilesh Kumbhani's candidature was cancelled by returning officer, the other independent smaller candidates who were contesting for the constituency of Surat, they basically withdrew their nominations, and ultimately it was Mukesh Dalal, the candidate of BJP, who was left alone as an important candidate and running a race with no opponents. So he was declared winner. But is there any particular law which actually provides that in certain cases contestant can be declared winner even before the election has been conducted? So the answer is yes. So this power comes from section 53 subclause 3 of the RPA 51, which provides that if there is a situation that there is only one contesting candidate with no opposition, election will not be held in that particular constituency, and even before the elections has been conducted, that particular contestant will be declared as a winner. And this is what has happened in the case of Surat constituency as well. Now, what legal recourse does the Congress party or Nilesh Kumbhani has in this particular situation or scenario? So we need to know that in the combined reading of Article 329 Clause B and certain provisions of Representation of People Act 1951, it provides that any dispute with respect to the elections can be entertained by only through an election petition. Election petition of the High Court, election petition of the concerned High Court, and this legal route is available only after the election is done and the results are out. So ultimately this disgruntled the Congress and the various candidates of the Congress, since they were not able to reach out to the corresponding Gujarat High Court with an election petition, and now they have to wait till the 5th of June till the results are declared. Now I'll request you to kindly pause your screen and go through the question and try to answer this thing. Consumption of tobacco by the public at large has been a major cause of concern for the public health. Karnataka government, to bolster the public health scenario in the state, recently had come up with certain legislative instruments and executive orders to ban the use of tobacco and similarly associated products like hookah, which led to a lot of legal petitions in the Karnataka High Court. The details of which we are going to see in the next slide. So, what is the context and the background behind this particular case? So recently, Karnataka government's health department had issued a notification in February 2024 which banned the sale, consumption and advertising of hookah. What do we understand by the term hookah? So as we already have seen that hookah is a kind of a device which actually helps the individual to consume tobacco, not only in the form of tobacco, but also it comes in forms of certain other flavoring agents which is very high in the content of nicotine. And that is why the Karnataka Health Department banned the sale, advertising and consumption of hookah. Similarly, very recently, Karnataka Legislative Assembly came up with the Cigarettes and Other Tobacco Products Karnataka Bill 2024, which banned and prohibited the functioning of hookah bars. Hookah bars are such restaurants or public places which provisioned hookahs to the youngsters or any adult who is coming to dine at the hookah bar. And because of these initiatives by the Karnataka government, it basically urged the restaurant owners or hookah bar owners who were making their livelihood through the servicing of such hookahs. So naturally what happened is that these hookah bar owners or the restaurant owners who used to service hookahs to their customers, they reached out to the Karnataka High Court and challenged the Karnataka government's notification and the bill also in certain regards. However, the Karnataka High Court, functioning towards the larger goal of increasing the public health standards of the Karnataka, upheld the government's notification and it provided a rational path towards the reducing the consumption of tobacco within the state. Now, before we go on and discuss the various aspects or the reasoning of the Karnataka High Court's judgment, first of all, we need to understand why at first place did the Karnataka government think to introduce such kind of a ban. So the first point we need to note over here is that the Karnataka government reasoned in the court that under entry 8 of the state list, it is the priority and the prerogative of the state government to increase the public health standards within the state. And since tobacco is one of the major causes of concern deteriorating the public health standards in the state, Karnataka government thought that it is in public interest that they should increase or they should introduce such a ban in the state so as to reduce or limit the consumption of hookahs and other related such products by the youngsters. The second important argument which the Karnataka government posited in the High Court of Karnataka was driven from the DPSP, that is Directive Principles of State Policy, Article 47. What does this Article 47 stands for? So Article 47 provides that it shall be the duty of the state to take certain efforts to increase the nutritional levels of its citizen. And secondly, the second part of the Article 47 reads like that the state should take concrete measures towards prohibition of what? Prohibition of intoxicating liquors or similar kind of drugs. So following the cue of the DPSPs, the Karnataka government had introduced the ban for the hookah and other associated tobacco products. And thirdly, it had been noticed that various hookah bars or the restaurants which were actually provisioning the hookahs, they were not following the fire hazard norms, and there had been multiple instances where the government noted that there has been instances of fire hazards and accidents leading to loss of man and property. And these were the primary compelling reasons through which the Karnataka government brought in the executive institution of or the executive instrument of notifications and also through the Legislative Assembly's bill also. Now, let us try to see what was the proper judicial reasoning. Why did the Karnataka High Court upheld the ban against the hookah and other associated tobacco products? So the first point that the Karnataka High Court noted is again they derived their reasoning from the philosophy behind the Article 47. Now, as we already discussed, that Article 47 has two components to it. Firstly, to increase nutrition, and secondly, to prohibit the consumption of certain intoxicating liquors or drugs. Now, under this drug category, definitely there is a place for tobacco, since tobacco contains nicotine and nicotine is extremely addictive, and secondly, more importantly, it's extremely carcinogenic. So, it is the state's responsibility to provide such an environment for its citizens so that they can raise the level of their nutrition, and secondly, they can reduce the consumption of whatever intoxicating drugs or alcohol that they are consuming, so that it will achieve into the actual utilization of Article 21, which is right to life and to right to live with dignity. So the court's argument was that if a citizen is not healthy and it is not having nutritious meals, so and it is totally consumed in intoxicating liquors or drugs, definitely due to poor health, the dignity through which is their fundamental right, it is compromised. And that is the primary reason that the Karnataka High Court utilized it to actually upheld the ban on the hookah and the related or associated tobacco products. Second point was, which majority of the hookah owners or restaurant owners had petitioned against the order of the Karnataka government, that ultimately this ban on the hookah and running of the hookah bars was against the provision of fundamental rights of Article 19 Clause 1 Subclause G, which provides the fundamental right to every citizen to actually profess any trade and business which they want to. But however, the High Court noted that this right which is emanating from the Article 19 Clause 1 Subclause G is not absolute in nature. It always comes with a reasonable restriction, and this reasonable restriction basically can be brought into action for larger public interest and public health. And that is why the Karnataka High Court upheld the ban on the hookah and associated products. The third was the important legal act which the High Court considered while providing its reasoning to uphold the ban was the Rule 4 Subclause 3 of the Cigarettes and Other Tobacco Products Act of 2003. Now, what does this rule provide is that this particular rule prohibits smoking in public places. Smoking in public places. You must have seen that whenever you must have visited some big railway stations or airports, there are very segregated smoking zones and no provisioning is allowed. Provisioning of foods, any sort of services is allowed within that particular smoking zone. And the Karnataka High Court took this logic itself while upholding the ban on the hookah parlor. That is why, because ultimately for all the restaurants and the hookah bars, the space where they were going to provide or provision the hookahs, they were also going to provide the food articles. And since the food articles, it will be provided in that particular space itself, it goes against the Rule 4.3 of the Quota, because it equates smoking cigarettes to using hookahs as well. So wherever the hookahs are being used, it is absolutely goes in contravention to the Rule 4 Clause 3, since any place is providing any place for using hookah, they cannot service any sort of food or any sort of service over there. And majority of the hookah bars or hookah parlors or restaurants were found to be in contravention with that particular rule. And these were the three major judicial reasonings which Karnataka High Court gave to actually uphold the ban which was provided by the Karnataka government. Now, these were the major initiatives which were taken by the Karnataka government to limit the consumption or to prohibit the consumption of tobacco and associated products by our youth and adults. However, we also need to keep in mind that what are the major interventions that the government of India is taking so as to limit the usage of tobacco and similar products, and so as to uphold the Article 47 of the Constitution of India, which provides that it shall be the state's duty to increase the nutritional standards, and secondly, the state should take concrete measures to decrease the consumption of intoxicating liquors and similar drugs. So let us try to see what the central government is trying to do with respect to the usage of tobacco. So the first important point we have to note over here, that in the National Health Policy which was released by the Ministry of Health and Family Welfare, it has created a very objective timeline and a goal set which the government has to achieve. So what does the National Health Policy is saying is that we need to reduce our tobacco consumption by 10% by 2020 and by 30% by 2025. And it is in respect to the baseline level of 2010 of the tobacco consumption use. The second important point we need to keep in mind is that the central government has tried to create a legal framework which will regulate the various aspects of the use of tobacco, whether be it consumption, commerce related to the tobacco, advertising, etc. So with the help of Control of Tobacco and Other Products Act, or the COTPA Act in short, the government tries to regulate the advertising and promotion of such tobacco products. Secondly, with the help of COTPA Act of 2003, the government is trying to prohibit the sale of cigarettes to the minors. And thirdly, with the help of COTPA Act only, as we have already seen in the previous slide, that government has prohibited the use of normal public spaces for smoking. So it provides for no smoking in public spaces. The next important intervention by the government has been the ratification of Framework Convention on Tobacco Control. Now, it is the primary global treaty which India is a party of, and India has played a significant role while designing or drafting the various important legal provisions of the Framework Convention on Tobacco Control. This FCTC in short was ratified by India in the year of 2004, and this basically governs the interstate or the international level of convergence between various kind of countries so as to limit the usage of tobacco, and secondly to prohibit any kind of international promotion and advertising of tobacco and related products. The fourth important point we need to note over here is a very important and flagship scheme which the government of India is running through the aegis of Ministry of Health and Family Welfare, is the National Tobacco and Control Program. Now, what the government is trying to achieve over here? First of all, awareness generation. So the government is trying to create awareness by conducting a lot of pakwadas or various kind of mass media campaigns so as to take the ill effects of tobacco to the larger public. Secondly, it strengthens the enforcement mechanism which is there through the various acts that we have, and not only at the central level but also at the state level. And lastly, through the fiscal resource, that government is trying to put very high taxes that we call the sin tax on tobacco and similar kind of intoxicating products which are quite addictive in nature, so that since it will be provided with sin tax, so the overall price of that tobacco commodity will increase, and ultimately it will lead to a sort of reduction in the demand for such kind of products. Now, for India to become a superpower, we need to first become a superpower which is powerful with respect to its human resources, and our human resources will only be powerful when the human resource is healthy, and the state governments and the central government, along in cooperation with the international agencies, has to work very hard to limit and prohibit the use of tobacco in the medium and the long term, so that it will have very larger dividends for our society and our country. Indian federalism accommodates a lot of diversity in the form of region, language and ethnicity. And since independence, Indian federalism has witnessed a lot of social movements to gain more and more autonomy over how the section of people actually are going to manage and govern their own affairs. And Article 244A of the Constitution is the result or culmination of a similar kind of movement which had taken place in the state of Assam. For greater details, let us go to the next slide. So, ultimately, our federalism is trying to accommodate a lot of identities, whether be it of language, whether be it of region or ethnicity or tribal identities. Now, you will be surprised to know that roughly 8.6% of our entire population caters to the scheduled tribes, which are almost 705 in number. So, roughly 705 scheduled tribes are listed in our country, who are spread in roughly 26 states and UTs. And majority of the characteristics of the tribal community is that they are aloof and they are not in convergence with the mainstream society, and through historically also they have been sort of aloof from the mainstream society, and they want to be kept like that only. And that is why there is a greater demand among the tribal societies, whether be it in the central India or in the hills of northeast or western Ghats. There has been a constant demand among the tribal communities so as to allow them them to govern themselves with respect to their own innate customs and traditions. And that is why there has been a very great and continuing demand for autonomy. And what are the major reasons? Why do these tribal communities demand for autonomy? First important point is distinct cultural values. Distinct cultural values. So as we already know that the tribal customs are extremely heterogeneous and they are aloof and they are sort of not convergent with the mainstream society, they want themselves to be governed which is driven by their own traditions, custom and heritage. That is the major important point. Second is the fear of discrimination. Discrimination by the mainstream society. So it has been the observation of various tribal communities, whether be it in the undivided state of Assam, when Assam basically emerged out of the independence after 1947. So there were a lot of emotion of discrimination within various tribal societies in Assam, that they were discriminated against the majoritarian society which was prevalent in the Brahmaputra plains. And thirdly, because of the economic deprivations. So because of the prevalent economic deprivations, majority of the tribal communities feel that if they are given the power to regulate their own affairs, they will be able to provide better governance so as to elevate their own economic and social indicators. And that is why there has been a persistent demand among various tribal communities and various regions to actually provide a sort of more autonomous powers. And what does the constitution is providing these tribal people so as to help them gain more autonomous environment to govern themselves? So let us try to look in the provision of Article 24. Article 24 is the most important constitutional article with respect to the administration of tribal areas and autonomous districts. That is, under Article 24, it is divided into two major important articles. Article 244, Clause 1, which provides for the 5th schedule areas, which is present in 10 states, and it provides for the establishment of tribal advisory councils, as we know. And second important article of Article 244 is 244, Clause 2, which provides for the 6th schedule areas, which is prevalent only in 4 states of Assam, Meghalaya, Tripura and Mizoram. And this 6th schedule provides for the establishment of autonomous district councils. Autonomous district councils, and these autonomous district councils had been created so as to provide a more decentralized governance at these 4 states. That is, the tribal representatives who are directly elected by the people are directly going to actually govern and to provide very good governance to the people of the tribal communities. So the Article 244A was not originally present in the Constitution, and it was added to the Constitution by the 22nd Constitution Amendment Act, which was taken place in the year of 1969. And this Article 244A, it provided for the creation of an autonomous state. Mind the keyword over here is that it provides for the creation of an autonomous state within the state of Assam. That is, this autonomous state will have its own council of ministers, irrespective of whatever council of ministers are already present there in the Assam state as a whole. And that is why it is actually, although it sounds quite synonymous with autonomous district councils, but there is a great degree of difference between autonomous state, which is being provided by Article 244A, and the autonomous district councils, which are being provided by Article 244 Clause 2 under the 6th schedule of the Constitution. Now, how does the autonomous state, which is created by the Article 244A, is different from the 6th schedule provisions? So ultimately, this autonomous state which has been created within the state is quite powerful when it compares to the regulation of law and order, because ultimately the people's representative elected under the 6th schedule do not have any power with respect to the law and order. And secondly, they have more financial control over the resources which they govern. And thirdly, they have more legislative competence. That is, under the Article 244A, it gives the power to the President to actually provide such kind of legislative matters to this autonomous state within the state, so that which might be deemed necessary for the larger public interest or of the tribal communities. However, that particular legislative competence is not there with the 6th schedule, which is formed under the Article 244 clause 2. Now, since we have already discussed the various important facets with respect to the Article 244A, we will try to basically discuss a brief timeline of how the demand for the autonomy within the state of Assam emerged and how it has evolved over the years. So, this demand for autonomy basically began as soon as we got independence from the year of 1950. So, the demand for separate hill states started emerging in the decade of 1950s. Now, since we know that the undivided Assam, when India got independent, the undivided Assam had completely all the 7 sister states that we know today. That is the Nagaland, Meghalaya, Mizoram, Tripura, etc. Now, during the 1950s, a lot of demands started coming up with respect to the creation of separate hill states out of the undivided Assam. Now, in 1960s, what happened is that all the political leaders of the undivided Assam, comprising of the hill states, they created an umbrella organization by the name of All Party Hill Leaders Association, which demanded or which escalated the demand for the separation of or the creation of new hill states. And what had happened with the prolonged agitation, it led to the splintering or creation of new hill states carving out of the undivided Assam. So what had happened is that in the year of 1972, ultimately it led to the formation of separate hill state of Meghalaya, Tripura, and similarly, as we know that because of the constant agitation and the procession was going on for the demand for creation of separate hill states, the central government had introduced the Article 244A for the state of Assam. Now, when these separate hill states were being created, the leaders of the Karbi Anglong and the Kachar Hills, the leaders of Karbi Anglong district, which is the hill state of Assam, and Kachar Hills. So the leaders of the Karbi Anglong and the Kachar Hills were given the option to either stay with the Assam or to join the state of Meghalaya. But at the same point of time, the Congress government of Assam had promised the leaders of Karbi Anglong and Kachar Hills that in mean course of time, they will be implementing the provisions of Article 244A, which was very acceptable to the leaders of Kachar Hills and the Karbi Anglong. So, in a way, they sort of trusted the promises of the Congress government at that point of time. However, it did not happen in that tune. And Congress ultimately kept on avoiding the petitions and the requests of the leaders of the Karbi Anglong or the Kachar Hills. And ultimately, when these leaders found out that their petitions and their requests and their agitations is not being heard by the Assam government, ultimately the movement which was there for the creation of separate hill states out of the Assam, it created a very violent movement. It created an extremely violent movement which led to the demands for a separate statehood. And ultimately, a lot of insurgency groups belonging from the Karbi Anglong leaders actually emerged, and ultimately this violence continued till the year of 2021, when in the year of 2021, roughly 5 militant insurgency groups basically signed a peace deal with the government of Assam. And these are the things that we need to focus, that ultimately every community wants to be governed in line with their own traditions, customs and heritage. And every community wants to have a say in the governance and the matters which actually concern them. And Indian federalism, after 75 years of its working experiences, has been very successful in actually trying to accommodate various kind of diversities which are there, and it is also evolving with time so as to provide even more dignity to the regional communities so that they can actually exercise and express their own cultural identities. Now let us try to solve this question. I will request you guys to kindly pause your screen and just attempt the question and try to solve it. Recently, the Andhra Pradesh High Court provided a judgment which can have a very far-reaching ramifications for the intellectual property rights regime in our country. The Andhra Pradesh High Court held that the textbooks comprising of scientific materials and mathematical equations are not covered under the copyright regimes or the Copyright Act of our country, that is the Copyright Act of 1957. To know more about the details of this case, let's go to the next slide. So the whole case or the background of the case starts with an order of the Andhra Pradesh government in the year of 2010. And in the year of 2010, Andhra Pradesh government came up with an order which actually prohibited or restricted all the private colleges and schools which are functioning within the Andhra Pradesh to actually publish the books which are released by the Andhra Pradesh government, and it directed all the schools and colleges to actually purchase all the books from the Telugu Academy. Telugu Academy is a proper governmental institution within the Andhra Pradesh government to sell the books to various schools and other institutions, including the students. Now, as there was one publication by the name of Deepti publication. So Deepti publication was a Guntur based publication unit which used to publish a lot of books which are published by the Andhra Pradesh. Now, as soon as the Andhra Pradesh government passed this order, Deepti publication challenged this order in the Andhra Pradesh High Court. And finally, the Andhra Pradesh High Court in the year of 2024, after 14 years of legal tussle and battle, in the month of April, it provided that all the textbooks which are comprising of scientific material and mathematical equations do not fall under the copyrights regime of the government of India. Now, before we go on and discuss the various reasoning which the Andhra Pradesh High Court has provided while providing this judgment, we would like to learn about what we actually understand by the copyright. So the term copyright is nothing but it is a legal term to describe the rights of a owner over their creative or artistic work. Now, what do we understand by creative and artistic works? So creative and artistic works can be of various types. It can be a poem, it can be an essay, it can be a painting, it can be a sculpture, and ultimately it can also be a software program. And the primary intent of copyright or any copyright regime is to provide the ownership to the creator of this artistic or creative work. Now, ultimately we need to also understand that what do we actually understand by the infringement of Copyrights Act. Now, whenever a person is using the copyrighted content, suppose, just to make you understand with the help of an example, suppose a book is copyrighted, and if any person tries to use that book without the prior authorization of the owner or the creator of that particular literary or artistic art, then it will be called as copyright infringement. So whenever a person is using any copyrighted literary or artistic art, whether be it any poem or essay or any journal, software program, without the prior authorization of the creator of that particular creative masterpiece, it will be labeled as copyright infringement. Now, to actually help you understand the various nuances and the reasonings which the Andhra Pradesh High Court had provided in the particular judgment, we would like to learn some basic sections of the India's Copyright Act of 1957, because these sections were duly used by the Andhra Pradesh High Court to come to that very crucial judgment. So the most important section with respect to the Copyrights Act, and which actually describes what can be labeled as infringement of copyright and what cannot be labeled as infringement of copyright, and which is section 52 of the Indian Copyrights Act of 1957. Now section 52 of the Copyrights Act of 1957, it talks about a doctrine of fair use. Now what do we understand by the term of fair use? So basically this fair use doctrine provides a list of activities. It basically provides a list of activities when it will be performed by an individual, it will not be considered as an infringement of the copyright. To make you understand very well and easily with the help of an example, for example, if I am trying to use a particular newspaper's article to illustrate it to you, or to do certain kind of research, or to review it, or to critique it, my personal work will not be categorized as the infringement of the copyrights of that particular owner or the artist who has created that particular piece of work. And that is why this fair use doctrine becomes of eminent importance, because ultimately with the use of fair use doctrine, courts not only in India but across the world has opened the doors so that larger sections of the society can get access to various kind of literature and knowledge. The second important section that we need to learn is the section 63 of the Copyrights Act of 1957. It basically provides for certain punitive measures for certain persons who are found to be violating the copyright laws. Ultimately, it provides for both jail terms and fine as well. And section 64 of the Indian Copyrights Act of 1957, which basically provides the power to the police to seize all the pirated copies of any original copyrighted work. Now, since we know the basic sections and the basic reasoning behind the Copyrights Act and the need of the copyright and what do we understand by copyright infringement, now we will be better able to understand the reasoning which the Andhra Pradesh High Court has provided while delivering the judgment. So, what is the judgment deal with? So, the first important point which the Andhra Pradesh High Court took into notice before actually providing the judgment that Deepthi publications could actually publish the textbooks which were provided by the Andhra Pradesh. So it took use of the fair use doctrine which had been ingrained in the Indian Copyrights Act of 1957. So the High Court held that whenever a textbook is containing any kind of scientific material or mathematical equations, it will not be used or covered under copyright infringement, since these are non-literary in nature. And that is how High Court of Andhra Pradesh utilized the fair use doctrine to actually broaden or increase the accessibility of such material so that other persons can also publish it. Second important point to be noted over here is that the textbooks are not covered under the Copyrights Act. As we already discussed in the fair use doctrine, that those textbooks containing scientific and mathematical equations are not to be covered under the copyrights regime, which is naturally flowing from the fair use doctrine. And the third important reasoning which the High Court gave while pronouncing that judgment is that ultimately in that order which the Andhra Pradesh government had provided in the year of 2010, Andhra Pradesh government order had provided that it restricted that the private schools and colleges should not be able to publish the books of Andhra Pradesh government. However, they never tried to limit any kind of publishing houses from publishing those books. So, based on these three proper reasoning, Andhra Pradesh High Court provided that whichever scientific material and mathematical equations are there in any textbook, mere arrangement or creation of a new material based on that particular material will not conspire into a copyright infringement. However, one important point we also have to note from the central level also, that recently NCERT had also issued a very advisory and a threatening notice to all the entities who are involved in piracy of various textbooks on the NCERTs, and NCERTs had warned such entities of due legal actions if these people do not stop the acts of piracy. However, in the central level also, in various judgments of Supreme Court, in Chancellor Masters and Scholars of Oxford University versus Narendra Publishing, reasoned in the similar lines with the Andhra Pradesh High Court. While deciding this judgment, Supreme Court opined that although the scientific equations and mathematical equations are nothing but just the representation of laws of nature, and if anyone is trying to discover it, nobody cannot have any monopoly over such mathematical equations and scientific laws or theories. And that is why Supreme Court again held that the Narendra Publishing House can actually print and publish whatever scientific and mathematical equations or the books that were being actually held by the University of Oxford. So while designing the copyrights regime of any country, one has to notice, or the government has to keep in mind, that the copyrights regime has to be designed in such a manner so as to secure the rights of the creator, and in the same hand balancing the access to the larger public so that they can utilize the various fruits of the artistic creation. The Election Commission of India has created the Model Code of Conduct to create an electoral environment which provides equal opportunity to all stakeholders and to conduct elections in free and fair manner. However, the violations of the Model Code of Conduct has been dealt by the Election Commission of India in a case-to-case basis. Of late, there has been an observation that the mode of handling of the violations of the Model Code of Conduct has undergone through a larger shift with respect to how Election Commission of India is actually tackling the violations of MCC. Now, before we go on and actually examine this shift which has come in the approach of how Election Commission of India deals with the violations of MCC, let's start with discussing what do we actually understand by the term MCC. So MCC is nothing but the Model Code of Conduct which is issued by the Election Commission of India to regulate the behavior and the conduct of political parties and candidates and other stakeholders while political campaigning and polling. Second important point we need to note over here is that how are violations dealt with it. Now, as we know that the Model Code of Conduct is not a legal document, and it cannot be legally enforceable by any law of parliament or any state legislative assembly. So ultimately, whenever there is any violation of the MCC is being done by any political party or any candidate, Election Commission has provided various advisories, and Election Commission has very explicitly delineated various points in the MCC itself that how the various political parties and the candidates itself can reach out to various officials of the Election Commissions of India like observers, returning officers, chief electoral officers, or for instance Election Commission of India, so as to complain about gross violations which any particular candidate or any particular political party has committed. And as soon as the Election Commission of India takes cognizance or takes into receipt the various complaints that they have received, then Election Commissions scrutinizes the complaints and then try to provide directives which has to be followed under the various laws which have been present in our Indian political system. Now, in the general elections which are underway to constitute the 18th Lok Sabha, it has been observed that Election Commission's approach in dealing with the violations of the MCC has gone a fundamental shift. It has taken a structural shift. Now, earlier, what had happened is that whenever a candidate or a political party used to violate the Model Code of Conduct, the Election Commission of India used to send notices to that particular candidates. But this year, while we are undergoing the elections or the general elections to constitute the 18th Lok Sabha, there has been a marked shift from that particular tendency with which how the Election Commission of India used to deal these violations. In this year of election, what has happened is that recently Election Commission of India has sent notices to the political parties in respect of or instead of the political candidates. So recently, Election Commission of India has sent two notices, one to Bharatiya Janata Party and another to Congress Party for violation of Model Code of Conduct by their respective candidates or respective star campaigners by the name of Narendra Modi, and for the Congress it was Rahul Gandhi. And this was actually observed by various observers and various experts of Indian constitutional law and the experts who observe Indian political scenario, and they have highlighted this marked shift that why did the Election Commission of India chose to send notices to the party when it can directly send the notices to the respective candidates itself. And when we draw a cross-comparative analysis with the earlier instances when such kind of high-profile candidates had been sent to notice, you will be surprised to know that in the elections of Gujarat state legislative election in the year of 2007, Sonia Gandhi was served individual notice by the Election Commission of India. And the same was happened with Mr. Narendra Modi in the year of 2013, and same had happened with Mr. Amit Shah in the general election of 2014. When Election Commission has sent earlier notices to individual candidates, it is very important point to note that why the Election Commission is trying to send notices to the parties and not to the candidates. And this is what we are going to discuss in the next slide. So what can we actually infer? From this changed stance of Election Commission of India in which it is trying to deal with the Model Code violations? Various political experts and certain ex-chief election commissioners have noted that the Election Commission, in its new approach where it is trying to send the notices to the political parties instead of sending it to the candidates, Election Commission of India is falling short of taking the action which is just and ethical. And in pursuance of this activity, Election Commission of India is trying to shun or diffuse the accountability which that particular campaigner has to take for their own conduct. However, the Election Commission's opinion in this regard is that Election Commission is of the opinion that Election Commission is going to take strict actions against those people who are repeated offenders or habitual offenders. But in the first instance, it is going to send the notices to the political party, and if such kind of instances repeat itself, then it is going to take note and send notices to the individual candidates for the violation of Model Code of Conduct. Now, as we know that it is the Election Commission of India's constitutional obligation to create an environment where every stakeholders of the political parties are being provided with level playing field, and secondly, to conduct the elections in free and fair manner. And we should be happy that the Election Commission has been performing in the best way possible to conduct the general elections to constitute the 18th Lok Sabha. Now, I'll request you to kindly pause your screen and go through the questions and solve it. Conducting elections in a humongous country like India is one of the most difficult tasks for the Election Commission to perform. And while performing those tasks, sometimes it happens that the polling processes gets disrupted. And this is what we are going to understand in this topic in detail. So, what is the context behind this particular news piece? So recently, the Election Commission declared void pollings in 11 polling booths of Manipur and 8 polling stations of Arunachal Pradesh. So what does the law suggest, or what does the legal frameworks which is driven by Representation of People Act of 1951, how does it decide what kind of situations will actually govern the voiding of the poll or adjourning of the poll, and what course of action does the law provides to the Election Commission of India and its officials to take the process ahead. So, to discuss this in detail, ultimately, the Representation of People Act 1951 identifies 4 important cases in which it provides the power to the Election Commission of India and its authorities to actually take into cognizance whether they want to adjourn the poll or to completely declare it void. So, the first case is when there is an intentional destruction, which is covered by the section 58 of the RPA. Now, consider as a situation that there is an intentional destruction of the EVMs, that out of malified intention a person gets hold of an EVM machine or either accidentally or intentionally tampers or breaks the EVM. Then, in that case, ultimately what needs to be done by the Election Commission of India? And that is what is being told by the section 58 of the RPA. So as soon as the returning officer of that particular constituency or the presiding officer of that particular polling booth gets into the idea, gets that information that a particular person has got hold of any EVM machine or EVM machines are being tampered, the same information will be provided by the presiding officer to the returning officer, and the returning officer, as soon as they will get the cognizance of the information, they will send it to the Election Commission of India, and the Election Commission of India then will ask the returning official to declare the polling in that polling booth to be void. Now the second important similar kind of things can happen in the booth capturing. And what do we understand by booth capturing? So as I'm very sure that you must have come across the instances of booth capturing in the movies, etc. Now what happens in the booth capturing is that certain anti-social elements or any certain members of any political party captures the entire operation of the booth, and it can also be in line with that certain members of the political party are threatening the voters which have gathered in the polling booth to cast their vote. In that condition, the section 135 of the Representations of the People Act, it provides the power to the presiding officer of that particular booth to first of all disconnect the central processing unit of the EVMs, and secondly to disconnect the ballot units from the EVM. And as soon as it is done that, the presiding officer sends the message or the information to the returning officer, who in turn sends that particular evidences and information to the Election Commission of India, and then Election Commission of India declares the polling in that booth to be void. And in due course of time, the Election Commission of India decides that at what kind of time and date that election can be held. Now the third case in this regard is whenever there is an occurrence of any natural disaster. It is extremely likely in a humongous country like India, having very diverse climatic conditions, that there can be a cases of storm, or there can be a very extreme downpour, or there can be a certain conditions may arise that there is a violent riot which has spread in the area, which is obstructing the electors to come to the polling booth. And in this condition, the section 57 of the RPA, it gives the power to the presiding officer to actually adjourn the elections or the election processes which was taking place in this polling booth. And as soon as the presiding officer, in consultation with the Election Commission of India, will decide the time and date through which they can again continue the process of elections from where they have left at that point of time. And the fourth important case that we need to keep in mind is that whenever a death of a candidate happens, so if section 52 of the Representation of People's Act 1951 provides a very unique provision that whenever there is a death of a candidate who belongs to a recognized party, so it gives the power to the Election Commission of India to actually adjourn the elections in that particular constituency. And similarly, Election Commission of India asked the party through which that particular candidate was contesting the election, and Election Commission of India asked that particular political party to field one more candidate, and then one more candidate within 7 days, so that the Election Commission can come up with the new date and time to conduct the elections. Now, as we know that the general elections are underway to constitute the 18th Lok Sabha of our parliament, and during this election, one of the most visible and evident symbol is the symbol or mark of indelible ink, which has become the classic symbol of Indian polls. What do we understand by the term of indelible? Indelible term means which is a marking mark which is very difficult to be erased. Now, to understand the various facets of this indelible ink, let's come to the next slide. So, what are the primary functions which are being served by this indelible ink? So, ultimately the ink is trying to serve two very important functions. Firstly, to separate the persons who have voted from the persons who have not voted. And it is one of the most cost-effective ways to actually identify the persons who have voted from the persons who have not voted, so that any person who have voted, they cannot come again and go for a dubious voting. And secondly, the second function which is being performed by the ink is more symbolic in nature. So the second important function is that it facilitates the assertion of identity of individuals and assertion of their democratic rights, that they can participate in the democratic processes of our country, which is their constitutional right. Now let us try to learn about various facets about the ink. So entire chemical composition of the ink is unknown. However, it is known to have silver nitrate, which is a photosensitive compound. Photosensitive compound means that as soon as light is exposed to this particular compound, this compound will turn into very dark purple blue color, and that is going to provide the color which has become the classic symbol for the elections which is actually going on right now. Secondly, this ink is always mixed with solvent in the form of alcohol, so that it helps the ink to get dried up very fast, so that as soon as a person has been applied the indelible ink, person will not get the opportunity to wipe it off, and the ink will definitely leave their mark. Now, coming to the usage of this particular ink. Now, the usage of the ink was started from the year of 1952, and it was used in the first general elections, and till the third general elections, the indelible ink was marked on the base of the forefinger of the left hand. However, one important point we need to note over here, that under section 61 of the RPA Act 1951, it provides the central government the power to create rules for the better conduct of the elections. And while utilizing this particular rule, and by utilizing this particular power, central government has formed Conduct of Election Rules 1961, and under this rules there is an important rule by the name of Rule 41 Clause K, and this Rule 41 Clause K, it provides that every elector who is going to cast the vote should be marked with an ink, and they should be marked with an ink on the tail of the nail of index finger. And if a person is not having the index finger, then it should be marked in the middle finger, and if a person is not having the middle finger, then it should be marked in the ring finger. Now, this was the various facets with respect to the usage of the indelible ink. Let's try to learn more about how the ink is getting manufactured in our country. So ultimately, the Center for Scientific and Industrial Research has created this indelible ink, and it has given the license to a country by the name of Madras Varnish and Paints Limited, short for MVPL. And MVPL is the only licensed company in our country which is manufacturing this particular ink. And you will be surprised to know that this company goes way back in history, when it was created in 1937 by the Maharaja of Mysore itself, whose name was Krishnaraj Vadiyar. And our ink production capacity has increased so much that India is trying to export ink to 25 countries, and putting our balance in payment account into a favorable condition. Now that was it for this month's Recitals in Depth or Polity and Governance. Stay tuned for the next one. Thank you.